A Will Guide. Chapter 1. Making a Will. The Will Info 1. At least half of all American people will die without leaving a will. The way the system is set up makes it a bad move for the heirs if you don't have one. Even if you're poor, you could suddenly get struck down in an accident and leave heirs to the positive end of a large wrongful death lawsuit. If you don't leave a will, your estate goes to what's called intestate. They will try to divvy it up to your relatives, but if they can't find them, the property goes to the state. If you die without a will, the state determines who gets custody of your children under 18. The first thing to do is to sit down, take an inventory of everything you own and put a dollar value on it. This is called your estate and includes residence, real estate, business personal property including partnership interests, copyrights, patents, trademarks, stock options, etc., vehicles, boats, etc., bank accounts and CDs, investments, stocks, mutual funds, and bonds, safe deposit box contents, time shares, life insurance, retirement accounts, IRAs, 401k, ESPs, KIA, business interests, personal things like clothing and furniture, jewelry, anything else. Then, list your liabilities by name and the amount you owe, including personal loans, credit cards, bank, mortgage loan, taxes due, current or past, life insurance loans, other personal debts. Add all of these numbers up to arrive at your total liabilities. Subtract your liabilities from your assets to arrive at your net worth. This allows you to place a value on your estate. You can see how close your estate is to the current federal tax limit. You can separate property by titled ownership and non-titled property. Knowing where you are in valuing your estate is an excellent start to your estate planning program. The basic elements of a will are your name and place of residence, a brief description of your assets, names of spouse, children, other beneficiaries such as charities or friends, alternate beneficiaries in the event a beneficiary dies before you, specific gifts such as a car or a house, establishment of trusts, if desired, cancellation of debts owed to you, name of an executor to manage your estate, name of a guardian for minor children, name of an alternative guardian just in case, your signature, witnesses' signatures. You don't need a lawyer to make a will, just common sense. If your estate is not more than the current federal tax limit and not extensive, you should be able to get by without a lawyer. State laws govern what makes a will valid. Generally, the conditions are: must be at least 18 years old, must be of sound mind, must be typewritten, must clearly state that it's your will and must be dated and signed by you, must be witnessed and signed by at least 2 or more people who do not inherit anything from your passing. The will should appoint an executor. The will must state at least one provision of property transference, i.e., I leave everything to my wife, Annie. State an alternative heir in case the first one dies. State debts owed to you. Name guardian for children under 18 with a second choice just in case. It doesn't have to be filed anywhere in order to be valid. Put your fingerprint on it for good measure. It doesn't have to be notarized, however, witnesses sometimes sign an affidavit before a notary public. Witnesses don't have to know what's in the will, just that you are making it. Lawyers can be expensive, lazy, and not in your best interest. That means they really don't give a damn about you and may even try to cheat you. Be careful when picking one. To save money on legal fees, your local legal aid society could help you if you are low income. Law schools sometimes offer legal clinics to the public. The federal government helps people with its Legal Services Corporation. You could try the AARP's legal service, aarp.org, or simply hire a paralegal. County court offices usually handle wills and probate matters. Call your county court and ask about specific conditions regarding wills. Other considerations are disposal of body, pets and conditions such as my son receives $30,000 upon graduation from college with a bachelor's degree. Keep several copies of the will with one in a metal, fire-proof box. When you die, the state only has the authority to open your safe deposit box unless it's jointly rented, so it may not be the best place to keep your will. If you move to a new state, check to see if their laws affect the legitimacy of your will. If you're hiding money or you get a safety deposit box, tell someone or leave a note somewhere where they will find it. Consider a common disaster clause in case you and your spouse both die. If you put general statements in your will, you're inviting fights among your heirs. Be specific. If you're scared that if you leave your wife a bunch of money, she will squander it and not leave it to the children, request a mutual will or a trust stating conditions on spending the money you leave her and who she will leave it to upon her death. If you don't leave a will, after probate, which can waste a lot of money, the money goes in this order to your spouse, descendants, relatives, government. You can minimize or even eliminate a will therefore probate by putting everything in joint ownership or a trust. A will becomes a part of the public record when it goes to probate. Anybody can look at it. Consider new technologies, both computer software, ready-made will kits and videotape wills. This is probably the best way to prevent challenges. To videotape yourself of sound, mental mind when making your will and stating such. Verify what's in your paper will. You could also write a personal letter of instruction, though not a legal document, that instructs your family what your personal wants are. If you have children, get a will made and name a guardian, because if you die tragically, it will save a lot of hassle for them. Try number 346 at the library. The will info 2. Many more women than men die without leaving a will. Even if your husband takes care of the finances, make it a point to make up a separate will for yourself. Beware of joint or mutual wills. Each spouse should make up their own separate will. The reason to make a will is because without it, your relatives have to go through probate where a judge decides who gets what. You never know when your time comes. It only takes an hour or so to make a will. Verbal commitments are meaningless. Put it on paper. You can probably get by with a free or cheap online will form, but if you have lots of money or children and several ex-wives, make a will with a lawyer. The basic tenets are: who will inherit your property? Who will serve as guardian to care for your minor children? Who will manage the property you leave to your minor children? Who will serve as executor of the will? A will could be as simple as, I leave everything to my wife. Chapter 2. Will topics. Holograph will. A holograph will is a will entirely written in handwriting by the testator, dated and signed. It's legal in most places. Joint will info. A couple makes one will for both of them. It usually leaves everything or almost everything to the living spouse and may give a few things away to others and have a provision for when the remaining spouse dies, the money will be given to the children. The problem is that when the first spouse dies, the joint will goes into probate where the conditions are frozen until the second spouse dies. What if you want to change the will? Why even bother with a joint will? Get all the big things you own in joint ownership, then there's no probate hassles. A mutual will info. A couple each makes up a separate will that are almost identical, that they will leave everything to their spouse. The executor of the will. In writing your will, you have to name an executor, somebody trusted like your spouse or a friend, to oversee your estate after death. The executor must be an American citizen over 18 who hasn't been convicted of a felony. He is legally obligated to act in the best interests of the deceased following the instructions of the will to the best of his ability. If the estate is large, you may opt to choose a professional like a lawyer or an accountant to oversee your will for a fee, usually 4% of the estate. Being an executor can be a lot of work. Pick someone who's willing to devote the time to work through the probate process diligently and fairly. The best way is probably to name a trusted family member and a professional who then gets only 2% of the estate. The executor should get the following paperwork. Letter of assets. Letter that says who'll get your minor personal stuff. Your will. List of any income coming in like rental income. Car registration forms. Bank account information. Business interests. Citizenship, birth, marriage, divorce, prenup, and adoption papers. Insurance policies. Investment accounts. Jewelry, expensive possessions. Loan, debt, and credit information. Military discharge papers for veteran benefits. Pension, possible death benefits. Pet information, who gets pets. Power of attorney forms. Real estate deals. Retirement accounts. Safety deposit box. Savings bonds. Social Security information for benefits. Tax returns. Titles to anything that requires a title like a boat, RV, etc. Trusts. An executor's responsibilities are: get the will. Get a lawyer if you need one. File the probate action with the court. Look in the phone book for the address, then go and get the application form. During probate, keep track of expenses. Get 10 copies of the death certificate and copy of will to bring to court. Contact all parties in the will. Contact insurance companies if they have claims to pay out. Notify financial institutions of the death. Make an inventory of the safety deposit box. Work through any will challenges. Once the will is deemed valid by the court, you can start to pay off debts and inheritances. Arrange for publication of notice to creditors and mail a notice to each known one. Send notices of the person's death to the post office, utility company, banks, and credit card companies. Inventory, appraise and oversee assets. Collect debts owed to the estate. Check with the deceased employer for unpaid wages, vacation pay, pension fund, etc. File for Social Security, veterans, and civil service benefits. File for life insurance benefits. File city, state, and/or federal income tax returns. File state and federal death tax returns. Pay bills and claims against the estate. Pay taxes, including income and estate taxes. Settle debts. Get the estate together until the property is disbursed. Disperse it at the appropriate time. Act in the best interests of the deceased. Mediate between squabbling heirs. Pay off the heirs and get receipts. The executor is legally entitled to receive pay for his services. Cancel credit cards, accounts, magazine subscriptions, etc. Finally, do the paperwork closing the will. Go to court and end the probate process. Things your executor needs to know are: what and where all your assets are and how to collect them. Copy of will, cemetery plot, marriage and divorce licenses. Copies of all retirement plans which owe money/death benefits. Name of income tax preparer. Names of insurance agent and insurance policies. All investment certificates and the broker who sold them if applicable for liquidation. List of valuables. Debts owed to you by anyone including the IRS. Copies of gift tax returns. How to stop CO owners of accounts and safe deposit boxes from plundering them. Financial statements of any businesses you own. If someone's been named an executor to a will and they can't or won't do it, they must file a declination with the court. The contingent executor then steps in. If there is no contingent executor, the court appoints one. A good idea for the intelligent disbursement of your will is to name 2 CO executors, a family member and an expert like a lawyer. Appoint a backup estate executor and attorney. Consumer Information Center. Pueblo, Colorado 81002. 888-878-3256. Pueblo.gsa.gov/cic_text/money/executor. Pueblo.gsa.gov/cic_text/money/executor/executor.htm. Booklet about being an executor. Change the will info. You may change your will in the event you feel like it. Your assets change significantly. You divorce or remarry. You have a child. You move to a different state. The executor of your will dies, gets very sick or has a falling out with you. One of your heirs dies or gets very sick. The laws affecting your estate change. Changes can be made with a separate document, called a codicil, that is witnessed just like a will, but a better way is to destroy the current will and draft up a new one. This is necessary if your marital status changes, one of your beneficiaries dies, you change your mind, your executor moves away, your estate changes drastically, etc. If you make a new will, state in it that you are revoking all other past wills. If you're mentally incapacitated, someone might contest the changes. Contest the will info. Anybody who makes a will doesn't want anyone contesting it. Put a no contest provision into your will that says anyone who contests or objects to the will gets nothing. Besides that, make the will fair such that everybody feels they got what they deserved. Be clear about everything. If somebody contests the will, the judge listens to the argument in probate court, then makes a judgment. It's not just family who contest the will. If the person owed a business or other person money, that person can come forward and provide evidence that this person owed him money. The most common reasons people contest wills is because they feel someone else got a lot more than them that they thought should have been more equitable. It gets messy with multiple spouses, stepchildren, etc. Some people try to claim the guy was mentally incompetent or someone put undue pressure on him when he was writing the will. Sometimes a person unintentionally forgets one of his children in the will. The court assumes that this happens and gives money to the omitted child. If you were a child of someone with a lot of money who doesn't believe he's your father, get a DNA test done, preferably while he's alive, to determine paternity. You can minimize or even eliminate a will therefore probate by putting everything in joint ownership or a trust. This way, nobody can contest anything. In some areas, your death has to be published in the local newspaper either in an ad or obituary to give possible creditors a chance to come out of the woodwork and contest the will. A will after a second marriage. After a second marriage, you more than likely have an ex-spouse, new spouse, kids from the first marriage, stepkids and new biological kids, so your best bet is to sit down, think it through and write it out. Call an attorney to review the will and sign it. Put the will in a safe place like the attorney's office, a friend's place, or in a bank's safe deposit box. Tell one family member where the will is located. If you have a prenuptial agreement, your will should be consistent with it. Update the will every 5 years or as conditions change. If there are minor children involved, make a provision for a guardian. Spell out provisions for the children of the former marriage clearly. Make special provisions like a trust for special needs children. Put in a provision for personal prized possessions like antiques, books, jewelry, etc. Make insurance policies beneficiaries the same as in the will. Make the survivor's benefits on bank accounts agree with the will. Consider probate and taxation costs to minimize these costs to the survivor at the time of death. Ethical will info. An ethical will is a will you make up describing your life and values, asking your family members to honor your memory by following the advice you offer in it. An ordinary will is about the disposition of material possessions at death. An ethical will is a summary of life a person creates to pass his or wisdom on to their relatives. Think of it as writing a love letter to your family. freeethicalwill.com. ethicalwill.com. Canadian Will. legalwills.ca. Chapter 3. Will resources. Will websites. You can buy will forms that you can have sent to you in the mail or download a file and print them out. Some are free. buildawill.com. cancer.org, Will Creation Toolkit sign up. easylegalforms.com. easylegal.com, 800-822-4566. fedpubs.com. findlegalforms.com. formslegal.net. freebusinessforms.com. freewillforms.com. itsmylife.com.